Mr. Grable, are you ready to proceed with Mr. Sepulveda?
We are, Your Honor. Thank you.
We have some breaking news just into our newsroom right now. We are just alerted Michigan authorities have arrested 2 people for killing a man in Lenawee County. The Michigan Attorney General says Michael and Ricardo Sepulveda killed the man in November of 1997 in Blissfield Township. Police say the victim was found nude and missing the head and both hands. The victim still has not been identified. No word on what led to those charges being filed. We do know Michael Sepulveda is being held at the Lucas County Jail. Ricardo is scheduled to face a judge tomorrow morning.
Okay, this is file 23-21463-FC, People versus Ricardo Sepulveda. We are here today for sentencing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Hoffman.
Thank you, Your Honor. Good morning. Benita Hoffman, Assistant Attorney General on behalf of the people. For the record, my bar number is P48738.
Good morning, Your Honor. Attorney Scott Grable, P53310, for Mr. Sepulveda. Myself and Mr. Sepulveda are here by Zoom, and we waive, obviously, appearing in person. Thank you, Your Honor.
All right, and sir, you are Ricardo Sepulveda, correct?
Yes, Your Honor.
Mr. Sepulveda, this is a sentencing in a felony case. As a result of that, you do have a right to be present in person here in the courtroom for the sentencing hearing. I would only continue by video conference if you are willing to waive your right to be here in person and continue by Zoom. Are you willing to do that at this point?
Yes, Your Honor. I'm willing to waive my in-person right to be at court.
Okay. Have you had an opportunity to read and review your pre-sentence report?
I have, Your Honor.
Have you had an opportunity to discuss that report with Mr. Grable?
Yes, we just a few minutes ago discussed it.
Are you satisfied with Mr. Grable and the advice that he's given you?
Yes, we went over a few things on the report that we feel needs to be edited or omitted.
Okay. Do you wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report?
Yes, we definitely would challenge some of the information, the accuracy of the information in there. I would defer to Mr. Grable to explain it.
Okay, Mr. Grable.
I would, Your Honor. First of all, Your Honor, I just want to make sure we sent to your staff, and we're filing a hard copy with the clerk's office, a sentencing memorandum. We've also given it to Ms. Hoffman from the Attorney General's office. For the record, I just want to make sure the court is in possession of that. And we do have a hard copy coming by mail as well. And I think Ms. Hoffman should be in possession of that as well.
I do have a copy.
Go ahead, Ms. Hoffman.
Your Honor, I do have a copy of the sentencing memorandum that was filed by the defendant's attorney.
Okay, and I have received and reviewed that as well.
Okay. Your Honor, I'll go into the report. There's just a few changes, Your Honor. On page 1 on the body, it says count 1, homicide, murder, first to be conspiracy. Just for clarity, Your Honor, I think it might be important just to change that to count 2, because obviously count 1 of the first degree premeditated, as the court is aware, obviously Mr. Sepulveda was found not guilty. I just think it might add some clarity because it is incorrect. It was count 2, not count 1. Not a big deal, but I still think it should be accurate on that point, just so Department of Corrections doesn't get confused. That would be my first change.
Okay, Ms. Hoffman, do you have any issue with that?
I do not, Your Honor.
Okay, so that should be modified to reflect count 2 was the homicide conspiracy charge.
Okay. On page 3 of the report, Your Honor, it indicates, again, count 1, homicide, top of page 3 of the report. It indicates, the charge is correct, conspiracy, but again, it references count 1 again for the same reasons I've illustrated. That should be count 2 on page 3. Again, same
Any
reason.
issue, any issue there, Ms. Hawk?
No, Your Honor.
And Your Honor, I'll probably reserve argument on it, but I'm going to ask on that paragraph on the top of page 3, I would indicate that, and again, I'll make the argument when the court is ready. It's outlined in my memorandum that Department of Corrections should be aware that Mr. Sepulveda is eligible for parole after the appropriate time period, but I could be more specific, or I can do it now based on the sentencing memorandum. I don't think there's any dispute, but we can come back to that later, Your Honor. I can make some other minor changes and proceed whatever the court's pleasure is.
Okay, so just, I'm sorry, going back to the labeling of the counts, it looks like they should probably, will all need to be renumbered.
That would be correct. I apologize, Your Honor. Just
make them-
sequentially to respect, right. I would agree, and I
make them-
apologize. That would be, I guess, instead of 2, 3, 4, 5, it should be obviously 3, 4, 5, and 6, or 2, 3, 4, 5, and 6 on those numbers sequentially.
Right.
You're correct, Your Honor. I apologize. They should be altered for the same reason, just for the housekeeping purpose to make it accurate.
Yeah, so he was convicted on counts 2 through 6 and found not guilty on count 1. All right, I'll save the parole issue for I think later. I don't think that's an issue with the PSI as much as it is what the sentence should be. So
That's correct, Your Honor. For the record, too, and I won't go into it, I did get a chance to speak to probation. I don't know if he's here by Zoom, Mr. Stevens. He agrees with me on the parole issue, and he can illustrate that himself. So he's not opposing that change. But I'll deal with that momentarily if he's here. He's consulted with Jackie Wise, the Lenawee County prosecutor, but he can verify what I'm saying. He agrees with me that this is parole eligible, but I wanted to mention that as well, but I'll ducktail back to that at the appropriate time with the court's permission.
all right, did you have any other additions, corrections, or deletions in the pre-sentence report?
I do. On the evaluation and plan, Your Honor, at the top, again, it indicates count 2 homicide, murder, first degree. Again, for clarity, I think it should indicate conspiracy to commit homicide. I think it's a little confusing. It looks like it has the correct count number, count 2, but it just indicates homicide, murder, first degree. I think it should indicate conspiracy to commit homicide, first degree, premeditated. Again, I think that would add the appropriate clarity to it. Again, I don't think it changes any of the dynamics, but I think it would be more accurate.
All right, Ms. Hoffman, any issue with that correction?
No.
Okay, so we will make that correction as well.
On page 2, Your Honor, under description of the offense, the paragraph that starts on 12098, Laura Lozana's former boyfriend, Thomas, and then it goes on. My understanding, obviously, I think that is in one of the incident reports that mentions that statement, but I understand, obviously, the court's aware, or maybe I have to refresh their memory. Thomas did not testify at trial. I think he was a subpoenaed witness, but I think they could not locate him. So for that reason, although I think there was some testimony that was outlined in the incident report, the fact that he was a no-show for trial, I would ask that whole paragraph and represented to Thomas should be deleted. But again, there was an incident report that I think mentioned that as a summary. But again, I think he avoided service. I think the court, and Ms. Hoffman will make sure I'm saying this accurately, I think there was a bench warrant issue, but maybe I'm confusing that with a different witness. If I am, I'm going to ask her to correct me because I don't want to mislead the court if I'm wrong.
All right.
So
Go ahead.
if I could respond, Your Honor, with respect to the missing witness, that the bench warrant was issued for, that witness was Billy Morgan, or William Morgan, which is his legal name. With respect to the comment made by Tommy Thomas, there were statements that were presented during the trial regarding Tommy Thomas. I think the correct way to handle this, if there is an objection, is that although Mr. Thomas did not testify at trial, an incident report says that he said this.
I would agree with Ms. Hoffman that I don't think simply the fact that he didn't testify at trial means that it can't be in the pre-sentence investigation report, because that report can include things other than the trial record. And so I think that the way that Ms. Hoffman has couched that phrasing would be appropriate, to simply indicate that although he did not testify at trial, there is an incident report which says the following. So I would make that correction.
Very good, Your Honor. One thing too, and I know we're going to address it, same page right under recommendation narrative, it indicates on count 2, the defendant served life without the possibility of parole. I just wanted to highlight it to the court's attention that obviously I'm going to object to that, but the court wants, if the court makes a ruling that may alter that, I'm going to ask they change that, and just to highlight it to the court for later analysis once we're done going through these changes. On the top of page 2, I just didn't want to forget, just to make aware that the court may change that or may not, but I'm saying I want it part of the analysis of changing that, where it says it's defendant served life without the possibility of parole. That should be addressed when the court does address it. I just didn't want to forget that, because obviously.
Okay.
Thank you, Your Honor. On the same page on 1/16/2002, it says Brahim Dahar, and then it goes on. This may be small. I think Mr. Dahar's testimony indicated during his then that they said there was some statement he stayed in the summer of '99 while at Laura Lozano's house. Again, this may be quibbling, but I think he testified during trial they were at his house. Again, I don't think it changes anything dramatic, but to be accurate, I think he indicated it was his house. Again, I don't think it changes the dynamic, but factually, I think that's what the trial record indicated under oath.
Ms. Hoffman?
Could you give that to me again, please?
Yeah, I'll clean it up. I think the statement indicates that there was some discussion about this murder. I think they said the meeting took place at Laura Lozano's house. I think Mr. Dahar indicated the meeting took place at his house. I agree that may not be salient to change anything, but I think that's what his trial testimony said. I want it to be accurate. I don't think it's going to change the nefarious nature of the conversation, but it's just for accuracy. I think it was a trial testimony.
So the issue is that the PSI says that the conversation occurred at Laura Lozano's house, and Mr. Grable says that the testimony was that the conversation occurred at Mr. Dahar's house.
That's I understand that's not an earth-shaking fact from a relevant standpoint, but Mr. Sepulveda brought that to my attention. I just didn't want to ignore it. Again, I don't think it's going to change the context of anything other than where the meeting.
Oh, okay. Ms. Hoffman, do you have any input on that issue?
Sure. First, the conversation regarding the plan to commit the murder began in Ohio and continued to Laura Lozano's house, as did
Okay,
the plan.
I'm sorry to interrupt, but you're not talking about the same conversation. This is a conversation that Mr. Dahar testified about, where Mr. Sepulveda told him that this had happened, not planning.
Oh, so I think that he actually testified that they were at Laura Lozano's home when he admitted he had gone to Laura Lozano's home, and they were in the basement at the home and they were smoking marijuana. I understand the confusion because the incident report says that it happened at Mr. Dahar's house, but I thought the testimony at trial was that it was at Ms. Lozano's house. I think it's either. I think the best way to put it is that it either occurred at Laura Lozano's or it occurred at Brahim Dahar's.
All right, I don't have a recollection of what the testimony was on that point, and I don't think it's a relevant point to anything that would have an impact on what his sentence would be or what would happen in the future regarding his sentence. So I would just delete the phrase "while at Laura Lozano's house" and just leave it that there was a conversation.
Fair enough, Your Honor. The last sentence in that paragraph indicates he indicated they decapitated him, excuse me. Brahim Dahar indicated that Michael and Ricardo had told him about the murder separately while they were in prison. For the record, again, small issue. Mr. Dahar and Mr. Sepulveda never served in prison together at the same facility, so I don't know if there were any reports indicated that they were not in prison together at the same time. Again, not a big issue, but Mr. Sepulveda brought it to my attention, so I'm bringing it to the court's attention. I don't think it's accurate.
Hey, if I could, Your Honor, it was Yusuf Dahar that served with Mr. Sepulveda in prison, not Brahim. Yusuf
All right,
was
so-
Brahim's brother. I'm sorry, Your Honor.
And I'm almost finished, Your Honor, after this.
I apologize, my memory's failing me. Yusuf Dahar did not testify, right?
Yes,
Yes, Your Honor.
I
That's
believe he's deceased.
I'm sorry.
I believe he's deceased.
Yeah.
Yes.
Okay, so then I would just strike and Ricardo from that statement.
Thank you, Your Honor. With the court's permission, I'll move along quickly to wrap this up. On 420.05, there's a paragraph about a call that referenced, I think, a 911 call, which there is an incident report that indicates that Butler Lozano testified, obviously, at trial, and I think it would be inconsistent with what was in the incident report. I think there was some impeachment attempt, but she never acknowledged that. I think, or it was Misty Reynolds who testified. Pardon me, Your Honor. I apologize. I don't think she confirmed she made the 911 call or anything that would indicate the context of that paragraph. So I'm going to ask that paragraph be deleted because although there was an incident report, obviously, I don't think she was impeached at trial. She denied having memory or her memory wasn't refreshed. So I'm just going to ask the court to delete that whole paragraph in reference to this 911 call.
Your Honor, it was Kathy Furl that made the 911 call.
No, it wasn't. It was Misty Reynolds.
Okay, Rick, don't interrupt. It's let the judge rule on it, please. Obviously, go ahead.
If I may interrupt, if you look at the incident report, there were a couple of calls to 911.
Well, this says Misty Reynolds, obviously, in the statement. So, and whatever the court rules is fine. I just wanted to bring, obviously, it sounds like Ms. Hoffman is not saying it was Misty Reynolds, or that's what the PSI says.
All right, there does seem to be at least some error in that paragraph, and I think, again, it only would have tangential relevance.
I agree.
I'm just going to strike the entire paragraph and leave that paragraph out.
Thank you. I'll try to wrap this up. On page 3, Your Honor, third paragraph down that starts on 12/2/16, there's mention of a family wake. And I remember the testimony at trial. They heard Michael state that he witnessed Ricardo kill and dismember a man. I think the testimony at trial from Michael was, or I think there was another witness, not from Michael. And the name escapes me, but I think the testimony was, your words are words to the effect, you're going to go down for murder, MF. I'm not going to say what the court knows what the word MF is. And then I think they said Mr. Sepulveda was silent and didn't respond. I think that's probably more of an accurate rendition of what the testimony was at trial than this statement that was contained in the report. So I don't think that characterization in the report that I referenced is consistent with what was offered at trial by one of the witnesses at the wake. That's it.
I agree with Mr. Grable, Your Honor.
Okay. So that paragraph should, end of that paragraph should read, they heard Michael state that Ricardo was going down for murder, which would be consistent with the testimony at trial.
Thank you, Your Honor. One more point in the, I guess, on page 3 in the body, and I'm going to skip down, I don't know how many lines, toward not the last paragraph, but the body of the polygraph where it's Toledo, Ohio area, down about 8 or 9 lines down. It starts at that point, Ricardo began to stomp the victim's head with his foot until he was deceased. I'm not sure, obviously, the client was acquitted of the first-degree premeditated murder. I don't know if it makes, at that point, he began to stomp the victim's head with his foot until he was deceased. I'm not sure. I would argue that the not guilty on the premeditated would make that statement, I guess, not supporting the record of the not guilty. So I would ask the court to delete at that point, etc. That one sentence. I would ask the court to delete that based on the not guilty of count 1.
Ms. Hoffman.
If we're going to change that statement at all, it should say that the defendant stomped his head until it was smashed in, while his brother hit the victim in the head with the butt of a pistol, and that he died thereafter.
I would defer to the court. I would just indicate the statement should be deleted, but I'll let the court rule on that. And that's my last change to the report, Your Honor.
All right, I believe that Ms. Hoffman's statement was an accurate reflection of what the testimony was at trial. I would preface the statement that that Michael testified that at that point. And I'm sorry, what was the remainder of?
So as the defendant was on the victim's head, his brother Michael Sepulveda was pistol whipping him, and thereafter the victim died.
All right, again with the preface that that is what Michael testified to at trial. That is what I would make that statement.
Thank you.
Thank you, Your Honor. And I
All right.
believe it's accurately scored as well, so I'm not challenging any of the scoring calculations on this as well, Your Honor.
All right, Mr. Grable, did the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
I don't believe it did, Your Honor, other than the issue of that we're going to address on the parolability of count 2. Other than that, that issue I do believe would be a constitutional violation, but nothing besides that issue that we're going to address. I believe it's acceptable.
All right, and you indicated that you have no issue with the scoring of the guidelines. Is that correct?
I don't have an issue, Your Honor. I believe, and to the relevant offenses, I believe it's accurately scored with the guidelines that were in place at the time the offense was committed, based on the time established at trial. I concur with that, yes.
Ms. Hoffman, did you have any issue with the guideline scoring?
I do not, Your Honor.
All right, and that was on the assault with intent to maim, 48 to 80 months.
I believe that's correct, Your Honor.
Yes.
Okay, so I have read your brief, Mr. Grable, with respect to the guideline scoring. I will give you a moment at this point if you want to say anything in addition to what you've submitted in writing.
I'll be brief, Your Honor. I'm not going to be circuitous. Obviously, I think the memorandum that we outlined illustrates that I think this is a absolutely black and white issue. I did want to add, Your Honor, I did bring this to probation, obviously Circuit Court probation's attention. I believe it was Mr. Stevens. I'm looking for his name in the report. I know it was signed by the supervisor. If I miscite who authored the report, he did contact me a couple days ago, and I don't know if he's in the Zoom meeting room. I'm hoping he is. So he'll confirm what I'm saying. he agreed with me that this is a parolable offense. He indicated that he consulted with Jackie Wise, who I understand is not the prosecutor in this case. Of course, she is the Lenawee County prosecuting attorney. He will confirm that she agreed as well. This is a parolable offense. Obviously, the law in place, Your Honor, in 1997, based on the rationale and analysis in my brief, makes this a parolable offense that, in my opinion, should be reflected in the judgment of sentence. Obviously, the law changed on this, I believe, in 2014. Obviously, the court's aware of ex post facto that obviously the punishment that was applicable at the time in 97 would make this a parole eligible offense, and you can't apply retroactively the 2014 modification to the statute. So clearly, this is parolable. I think the case law is clear. I don't think the case, I think Ms. Hoffman gave me a case that was a 1986 case. It doesn't apply or change the rationale here. My position, in my opinion, is crystal clear and correct. I'm sure the court, knowing I know the courts, how the court handles these procedurally, I'm sure the court did a copious review of this. So I'll defer to the court, but I do believe everything in the report that indicates this is not parolable should be modified to parolable, and it should be included in the judgment of sentence. I believe it would be parolable after 15 years. Obviously, it still has to go through the parole board, but it is parolable in my opinion. I think it's absolutely unequivocally clear based on the case law I cited in my memorandum, which I incorporate. Thank you.
Ms. Hoffman.
Your Honor, turning first to the issue of parolability, the statute does specify that the defendant is to be sentenced to life in prison. It does not say non-parolable life in prison. So I agree with him with opposing counsel regarding that particular issue. However, that does not automatically mean that Mr. Alford is going to be eligible for parole or that he's going to receive a shot at parole in 15 years. Michigan Department of Corrections guidance on this says that the person can be considered, but at the time in 1997, the policy of the Michigan Department of Corrections was that life meant life. And part of the reason for that is because a first-degree homicide conviction or conspiracy to commit first-degree homicide, by simple logic, should carry a harsher penalty than a second-degree murder charge, which also carries life for any term of years. And so for that reason, I believe that the pre-sentence investigation report need not reflect that he's eligible for parole in 15 years, because once he gets inside the Department of Corrections, it is up to the Department of Corrections. There is federal case law on this issue in terms of whether or not being granted parole or being denied parole such that the person winds up serving life without parole is an ex post facto violation. And the Sixth Circuit, as well as the Michigan Supreme Court, have both concluded that it is not. If opposing counsel had served me his sentencing brief sooner, I could have gotten a response put together. I can find the cases for the court if the court would like that. One of them is People versus Neely, and then the other one is People versus Fernandez. And then the third case that I wanted to bring to the court's attention was the, hold on, I will find it. Give me 1 second. I had it open. The one is People versus William Edward Neely, and it is case number 165185, which was issued July 8th of 2024.
So
And
it's
then
not reported?
it is reported. All Michigan Supreme Court cases are reported,
Well,
Your Honor.
can I have the site?
I don't think it's been reduced to a site yet, Your Honor, because of the way they publish the volumes. But if you'll give me 1 moment. Yeah, I only have, Your Honor, I apologize. I only have the case number, which is number 165185, and it was issued July 8th of 2024 by the Michigan Supreme Court.
And I'm sorry, what were the other cases that you mentioned?
People versus Neely was one, and the other one was Foster Bay versus Sampson. But it's an unpublished opinion, Your Honor.
So I guess, let me just see if I can understand clearly, Ms. Hoffman, do you agree or disagree that the court cannot sentence to life without parole?
I believe that that is correct. The court can sentence to life and make a recommendation that he not receive parole, but I don't think that the court can issue a sentence of life without parole. And the distinction is that if the court were to recommend no parole, that would be a recommendation that the Department of Corrections Parole Board would receive, and they have the authority to determine whether or not he's eligible for parole, or will receive, I should say, whether or not he should receive parole at 15 years. So I'm asking the court to sentence him to life and to recommend that he not be granted parole.
I would object to that, Your Honor. I would let the parole board decide. I've never seen a court put in there that you're recommending against parole. I've never heard that in the judgment of sentence. Again, to be respectful, obviously, once I determined this became an issue, I served the sentencing memorandum. I have not reviewed the cases, obviously, that Ms. Hoffman made. I can agree with her. She needed additional time. I certainly wouldn't have posed an adjournment for the sentencing today so she could submit those citations. Obviously, Mr. Sepulveda is in jail. He's not going anywhere. But either way, Your Honor, I don't think any of those cases are going to stand for the proposition. And again, I haven't read them, but it doesn't sound like they stand for the proposition that the court can now function as the parole board. I'm recommending against parole. I don't think so. I don't think it's respectfully, I think the court has wide powers, but I don't believe the court should now put their hat on as the parole board to recommend against parole. I've never seen that in my life. I think it should indicate that he has the possibility of parole, and I think that's what the judgment of sentence should reflect, and let the parole board make the determination, not the circuit court. And I say that with respect to this court. I understand they have equitable powers and some plenary powers, but I don't think that language would all be appropriate in the judgment of sentence. I don't believe any case law or anything supports that. But obviously, I'll defer to the court, but I think I'm correct on that issue. Thank you.
Your Honor, if the court is inclined to follow Mr. Grable's analysis, then I would recommend that the court sentence the defendant to life in prison and not say anything about its eligibility for parole, and let the Department of Corrections follow its internal procedures and statutory authority when determining whether or not he's eligible for parole. Because there is a distinction between being eligible and being granted, and MDOC has had in the past a policy that did not allow parole for a first-degree homicide offense or for conspiracy to commit first-degree homicide. And it was upheld. It wasn't considered an ex post facto violation of the law for that to occur, because the discretion to grant parole is completely within the discretion to grant or deny parole rests with the parole board, although the court can be consulted with respect to whether or not parole should be granted. That was the procedure back in 1997. So to simplify, I'm just asking that the court sentence him to life in prison, and perhaps just not say anything at all about parole.
I didn't mean to cut Ms. Hoffman off. Were you finished? I didn't want to cut off your thought.
As to the parole issue, yes.
Okay, that's fine. Judge, the only language I put in there in my memorandum, I think it speaks succinctly.
Mr. Grable, I apologize for interrupting, but I've read the memorandum, and so the continued back and forth at this point, unless you have something new, is not is becoming cumulative. So
Okay, fair enough. Your Honor. I think it should say is the life set that.
Okay, thank you, Mr. Grable. Thank you. I know what you think it should say.
All right, well, I won't say anything further. I think the court certainly is aware of the argument. Thank you, Your Honor.
What is clear to the court is that the law as it existed in 1997 is the law that the court has to apply in sentencing today. At that time, as Mr. Grable has pointed out in his memorandum, the law did not have a provision for sentencing a person to a life sentence without parole. And so the court does not have the power to sentence Mr. Sepulveda to a life sentence without parole. And that is how the court is going to operate today. I'm not going to get into what the policies of the Michigan Department of Corrections were in 1997 because it's not my job to make or apply those policies. It's the job of the Michigan Department of Corrections to apply those policies. So that's how I intend to treat this matter. Did you have other issues you needed to address, Mr. Gray?
No, Your Honor, I just want to make sure with the court's guidance, what areas of the pre-sentence investigation report that's modified to reflect the court's ruling. And I'll let the court put on the record what they want to change. I've noted a few places that I think would hopefully, and I'll let the court decide, should effectuate what the court just said.
To the extent that the report has any indication of the sentence being without parole, I would omit any such references.
And I think, obviously, I've highlighted the areas, Your Honor. I'm not going to repeat them as long as it's notated in the final version. I just want to make sure that doesn't add any. I think you were crystal clear. I just want to make sure the report doesn't confuse Department of Corrections because we may potentially be revisiting the issue in 15 years. And I think as long as the court makes the notations, I'm certainly satisfied with that, Your Honor. I think the ruling was, you made it clear. Other than that, Your Honor, I won't take up the court's time on this issue. I think it made its ruling.
All right, Ms. Hoffman, did you have any additions, corrections, or deletions? I don't believe I ever asked you that question.
No, Your Honor, I don't.
All right, before the court passes sentence, then, Mr. Grable, is there anything you want to say on behalf of Mr. Sepulveda?
Well, Your Honor, the court heard lengthy testimony. So as far as allocution, I'm simply going to ask the court, other than the modification for the parole, to follow the recommendation, Your Honor. I don't think there's much that can be said that isn't said in the pre-sentence report. So I'm just going to ask the court to follow the recommendation, Your Honor, obviously, other than the parole modification that the court has opined on. Other than that, Your Honor, I'm not going to say anything else. Thank you.
Mr. Sepulveda, is there anything that you would like to say on your own behalf before the court passes sentence?
No, Your Honor.
Your
Ms.
Honor, I'm sorry. Do we have a concession that there is a prior felony conviction for the purposes of the habitual offender supplement? It's referenced in the report. Opposing counsel didn't object to it, but I want to make sure that that's established.
I believe it's established, yes.
Thank you. I do wish to allocute if the court would allow.
Go ahead.
Thank you. Your Honor, this was a horribly gruesome crime that was related to drug trafficking in Southeast Michigan and Northwest Ohio. In all of the things that the court has to consider, one of the things that is significant is that this victim was kidnapped from Ohio and brought to Michigan, where he was brutally murdered and then dismembered. The defendant's conduct was clever. It was calculated. It was goal-oriented. It was plainly premeditated. He scattered the evidence along with his brother in a way that made it impossible for law enforcement to identify who the victim was, and which successfully kept his involvement in the crime hidden for several decades. The savagery of the crime is just beyond explanation. To imagine being kidnapped, hit over the head, stabbed, taken into a field, stomped out, hit with a pistol, and left for dead. And then to have them come back and say, oh no, that wasn't good enough. We have to go back. and then cut off his head and cut off both of his hands so that no one could identify him. And to make matters worse, they further desecrated the body by pouring some sort of a solvent, bleach, possibly Drano, over the victim's body so that no trace evidence could be found, so that no identification of this victim was possible. And here we are, several decades after the offense. We still don't know who the victim is. We don't know the true identity of the victim. Somewhere, whether they're good law-abiding people or not, there is a family that needs to know who this victim was so that they can know for sure what happened. And perhaps the worst part about the crime, in addition to the severity of it, the brutality of it, is the unlawful motive it served to achieve, and that is to avoid paying a drug debt to a cartel. I respectfully submit to the court that in addition to the sentence being imposed for the defendant for life in prison for the first offense, that the court should depart from the sentencing guidelines on the lesser offenses and sentence the defendant to 10 to 15 years on the minimum sentence because of the severity of the crime, because of the brutality with which the crime was committed, because it was organized, premeditated, related to cartel involvement, because it was beyond what was necessary to kill the person. The state firmly believes that the defendant should go to prison for the rest of his life. The state also firmly hopes that the Department of Corrections never allows Mr. Sepulveda to be granted parole and never allows Mr. Sepulveda to rejoin society. He's too dangerous. He's too dangerous, and his connections in the outside world in civilized society are connected to the uncivilized portions of society, those who resort to this kind of violence to continue to profit, to protect their profit margin from the trafficking of cocaine and fentanyl and heroin and marijuana. For all those reasons, we ask the court to sentence him to life in prison for the conspiracy to commit murder. And we also ask that the court depart from the sentencing guidelines for the objective and verifiable reasons that are not covered by the sentencing guidelines and sentence him to 10 to 15 years on each of the lesser offenses. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Sepulveda is 53 years old and has been convicted of conspiracy to commit homicide, first-degree murder, assault with intent to maim, 2 counts, and tampering with evidence, 2 counts. Court obviously sat through the trial and heard all of the testimony in this case. And I would agree with Ms. Hoffman that this was a particularly gruesome offense, the likes of which I certainly have never seen before in my time on the bench. And it resulted in the death of a person who is still unknown, at least to us. And somewhere in this world, there are people who have grieved the loss of a son or a brother or a husband or whatever relationships that this person has when he was murdered. It also occurred in the context of a drug dealing operation. And so there was, although not charged in this case, testimony of significant other criminal activity that was going on. Which it appeared from the evidence to be primarily orchestrated by Mr. Sepulveda. In looking at the guideline scoring on the assault with intent to maim charge, the guidelines ended up at 48 to 80 months. I would note that the offense variables were scored at 115 in this case. And when we look at the severity levels as they go up, we're well beyond the top, the minimum score for the top level of the offense variables. And I think that speaks to, again, the gruesome nature of the crime and what occurred here. With respect to the conspiracy to commit homicide case, I've stated it already, but the law that applied in 1997 is the law that applies to this case. In 1997, the law had no provision for sentencing a person to life without possibility of parole. It simply said that a person guilty of this particular crime would be sentenced to life in prison. And so that will be the sentence of the court on count one, that Mr. Sepulveda be sentenced to the Michigan Department of Corrections for life with credit for 878 days served. There is in that file, $130 crime victims' rights fee and $340 state cost. With respect to the remaining counts, the 2 counts of assault with intent to maim, which include a habitual offender, as well as the 2 counts of tampering with evidence. I do believe in this case that the guidelines do not adequately address the particular circumstances of Mr. Sepulveda, and they do not adequately address the circumstances of this crime, particularly the gruesome nature of not simply murdering a person, but in the context of doing that, also kidnapping that person, taking them across state lines to try to conceal, finish the job, essentially, try to conceal the body, and then come back later and cut the head and the hands off of a person to conceal that person's identity so that they would never be known. And again, to this date, that identity is not known. I think that goes far beyond and is more heinous, more savage, more gruesome than even the vast majority of the murder cases that we have to deal with. And so I do think that a more proportionate sentence on those counts would be 10 to 15 years rather than what the guidelines would call for. And so that would be the sentence of the court with respect to counts 3, 4, 5, and 6. All would be 10 to 15 years with credit for 878 days served. Those sentences are all concurrent with each other. Mr. Sepulveda, you do have the ability to request an appeal of your sentence we will send to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. When you get those forms, you'll need to sign 1 copy and return that to the court. It just indicates that you received your copies of those forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that, sir?
Yes, Your Honor. I would ask the court in the meantime to recognize that I'm going to proceed pro se until such a time as I can fill those forms out following today's hearing. I mean,
all right. That is fine. If it's your wish to represent yourself at this point until you get those forms, that is your right.
Your Honor, could I also ask the court, I don't know if this is the proper time or not, to provide me with a copy of the trial transcripts and any of the evidence exhibits?
I think those might have been ordered, but I will check, and if they have not, we will enter an order for those to be prepared.
Thank you, Your Honor.
All right. With that, then you can let the officer that's with you know that you are done with court for today.
Oh, one last thing, Your Honor. We haven't you haven't talked about court costs or anything like that?
I think he did. I think the court
did you?
indicated there was 130, 340. Obviously, for the record, the client's indigent, Your Honor, but obviously the court's ruled on that, but I think I'm not going to address that other than these indigents.
Okay, so I guess just for, could you please repeat what my total costs are or whatever, Your Honor, just so I have a clear understanding?
The crime victims assessment is $130, and there's a state cost of $340.
And where do I pay those to, or is there any possibility of getting?
I can advise you on that after.
Is there a possibility of getting any of those costs waived or reduced?
So I've waived all of the costs that can be waived and assessed the ones that I'm required to assess.
Okay, understood. Thank you, Your Honor.
All right. So if that's all, then you can let the officer that's with you know that you are finished with court.
All right.
Thank you.
Your Honor. Thank you, Mr. Grable.
I appreciate it. Thank you, Judge. Thank you, Ms.
Thank you, Your Honor.
Okay, the first one I'm showing is Christopher Harold, which is case 25 CR 240. And Mr. Harold is present. These hearings are all being conducted by Zoom. Mr. Regier is here for the Butler County Attorney's Office. And looks like this is a first appearance for you, Mr. Harold. Can you hear me okay?
Yes, ma'am.
Okay. So what I'm going to do is go through the complaint with you, make sure you understand what you are charged with. And then we'll talk about bond. We'll talk about you getting an attorney and any other issues that the state or you may have at this point. So this complaint contains 2 counts. Both are alleged to have occurred on November 23rd of 2024. Count 1, that you did recklessly expose another person, that being a Joanne Spranroff Regetz, to the danger of great bodily harm. This is a violation of KSA 21-5429A. It's called endangerment, which is a Class A person misdemeanor. Count 2, on the same date, that you did unlawfully as the owner or custodian of an animal of dangerous or vicious propensities, and knowing of such propensities, permit or fail to prevent the animal, in this case it was 2 large mastiffs, to go at large or kept without taking ordinary care to restrain the animals in violation of KSA 21-6418. It's called permitting dangerous animal to be at large. That is a Class B non-person misdemeanor crime. Do you understand what you are charged with? Not whether or not you agree with them, but just what you are charged with.
Not completely, but I not to interrupt you, but I do have an attorney. I did retain an attorney,
Okay,
and I see that he was not able to join us today, or he's not able to join yet.
that,
I gave him all the information.
do you think he was going to be here?
Yeah, he said he was going to be there. His name is
Okay, what's his
Stephen
name?
Stephen Aragno,
Uh-huh.
ARIAGN0. I'm
Mm-hmm.
sorry. Is it, oh,
Yeah, I know who you're talking about. Okay. Well, okay, let's wait just a bit on your case.
okay.
Mr. Regier, we'll see if his attorney joins us. And if not, Mr. Harold, that's okay. We've got it written down that that's who you're going to hire, and we won't have you say anything or do anything at today's hearing that would upset your attorney, okay?
I appreciate that. Thank you.
Okay, let's go on to Mr. Fell. This case number is 23 CR 174. Mr. Fell, can you hear me okay?
Yes, ma'am.
Okay. So I'm looking for this. Mr. Regier, what do you have on this one?
Honor, this appears to be a case where on September 22nd, 2023, a journal entry of felony conviction and sentencing was filed with the court from a sentencing date in July of 2023. More recently, I am showing a request for revocation that was filed with the court on November 18th, 2024. This would appear to be the second such request, as I am showing a similar filing from the court, having been filed with the court in July of 2024.
Okay. So, Mr. Fell, the state is requesting revocation of your probation under a felony sentencing last year. And Mr. Fell, I just want to find out if you're going to hire an attorney on this.
I thought they had appointed Favre back to it, my original attorney on the case. That's what Trump said.
Have you been in contact with that attorney?
No.
Why not?
I don't know.
Waiting on him to call
Hey.
you?
Well, once he was reappointed, I figured he'd send a letter or something.
Yeah. Well, it's your case. It's your responsibility to contact your attorney. So you need to make sure you get that done just as soon as possible. I don't see any attorney on here for you. Mr. Regier, do you show that anyone's been reappointed yet?
Your Honor, it would appear that previously an order appointing counsel with respect to Mr. Watts was filed with the court in July of 2024. It would appear that shortly thereafter, a hearing was conducted in September of 2024. However, I'm not sure if the court is prepared to make a finding at this juncture that counsel for the defense, as court appointed counsel, has any continuing obligations in this matter at this time.
Mm-hmm. Okay. So Mr. Watts's representation of you would have ended, once the case was sentenced, basically. So what's your situation with regard to employment and whether you need court-appointed counsel?
I court appointed.
Yeah. Why? Are you working?
No.
No?
No, not right now.
Yeah. When was the last time you worked?
It's been about a month and a half.
Okay. And what happened with that job?
I got fired, but I never got a reason why I was fired. So I'm not really sure what happened.
Okay, where were you working?
Site Force Construction.
Okay. And so for the last month and a half, what have you been looking for work, I assume?
Yeah.
Do you have any funds available to put towards your defense?
Not right now, no.
Are you, do you have family? Are you married?
No.
Okay. At this time, I will go ahead and find that you are indigent, reappoint Mr. Watts to represent you. And we'll set this over. Would this be on a, what doc? Oh, a warrant to show cause docket. And let's see, your judge is
It
Judge
was
Crump.
Crump.
Okay,
Yes, ma'am.
okay. And so his next hearing date would be July 25th, and that would be at 2:30.
25th at 2:30.
Mm-hmm.
And he will need to appear at the courthouse for that.
Okay,
Yes,
so
ma'am.
Mr. Fair, you need to show up at the Butler County Courthouse for that hearing.
Okay.
So Mr. Watts has been reappointed. You need to contact him.
Okay.
Okay. And did you post a bond?
Yeah.
How much?
It was $5,000.
Who's your bondsman?
Brad Geist. Yes, he's with Owens Bonding.
Okay. Mr. Regier, do you have any requests with regard to bond or any other issues on this case?
Your Honor, if the assigned district judge has already made orders concerning bond and such a bond has indeed already been met, although I do not have a copy of such a bond in my file, the state does not see any reason, nor would the state be inclined to suggest any modifications.
Okay. So you've got an attorney, you've got your new court date, you've got court orders to appear at the Butler County Courthouse on July 25th at 2:30 for that hearing. Any questions?
Yes, ma'am. No, I don't.
Okay, you're free to go.
Thank you very much.
So Mr. Harold, I'm back on your case now. This is 25 CR 240, and I'm not showing your attorney has appeared. And that's not unusual. It's okay.
I know he was in court today and he said he was going to try to get away to a chamber or something like that and dial in. He didn't think there'd be a problem, but that
Okay.
might have changed.
Might have changed, and that's okay. So I read the charges to you. Both of those are misdemeanor charges. Count 1 is a Class A misdemeanor. Count 2 is a Class B misdemeanor. If you were convicted on the Class A, the maximum penalty is 1 year in the county jail and a $2,500 fine. On the B misdemeanor, the maximum time in jail is 6 months. So those are the maximums, and I'm required to inform you of what those are. I will, at this time, go ahead and enter pleas of not guilty for you since you do have an attorney. And these would next go on the misdemeanor control docket, which would be September the 8th. No, is that right?
Yep, that's right.
Okay, September the 8th at 9 o'clock.
You say September the 8th,
Yeah.
9 o'clock?
September 8th at 9 o'clock. Make sure you let your attorney know about that court date so he can make arrangements to be there. It's quite a ways from now. Did you post a bond?
No,
It needs
I-
bonded
no,
and processed, Judge.
Okay, okay, so you weren't arrested. You were issued
no,
a
I've just,
summons.
I've never, nothing like this.
Okay, okay. So you've appeared today, Mr. Regier. What would the state be requesting with regard to a bond?
Your Honor, given that the defendant appears in the fashion that he does today, the state is not opposed to an OR bond in this matter. However, the state will be requesting a very high bond in this case insofar as an amount is concerned. It's the case where pursuant to paragraphs 5 and 6 of the affidavit, it is alleged that the victim's body was observed covered in blood with extensive injuries, as well as referred to the victim being mauled by 2 bull mastiffs belonging to the defendant. Paragraphs 8 and 10 appears to refer to multiple prior incidents involving the defendant's dogs and the defendant's dogs being permitted to run at large as far back as 2021. Therefore, the state is requesting a bond amount of $5,000.
Okay, and I see Mr. Areno has appeared. So we waited on you a bit. I'm sorry.
Nice to see you, Judge. I had some connectivity issues, so I apologize. So
Okay, well, I entered pleas of not guilty for your client, read the charges to him, and we were just discussing bond. He is appearing today on a summons, so there's not been a bond, but the state is requesting 5,000 OR.
I don't have an objection to an OR bond, Your Honor. My client has no criminal history. Obviously, I believe it's appropriate. As I understand it, the dogs have been put down too immediately after this incident. We
Okay.
think that OR bond is appropriate.
Okay, so it'll be a 5,000 OR bond, and your client will have to be processed on this. And I'll ask court security how you want to set that up.
I think they're muted.
Just have Mandy put him in a breakout room with me.
Okay,
Court security too. Court
you want-
security too.
do you want to go to Steve?
Actually, well, yeah, why don't you go ahead and place me in that breakout room as well?
Okay, okay. And then once you've made those arrangements, oh, I got to give you a court date. I did.
What is
And
that court date, Your Honor?
it's September the 8th at 9 o'clock.
Is that in front of Judge Webster?
Yes, it is.
Very good.
Okay, so when you're finished with the breakout room, I think you'll be finished with us and you can sign off.
Very good. Thank you. Very
Okay.
nice to see you again, Judge.
Yeah, you too. Thanks. Okay. Let's move on now after they are. Okay. To, I've got someone at the Butler County Detention. What's your name?
Kenneth Corson.
Kenneth Corson. This is case 2022 CR 314. And Mr. Regier is here for the state. Mr. Corson, it looks like this is on a warrant to show cause. Bond has been set at $2,500 cash or surety. Are you going to hire an attorney to represent you on this warrant to show cause?
I don't know what that means.
If you're going to hire an attorney,
To show cause for what?
Mr. Regier, what's the state's allegation?
You're muted, Mr. Regier.
Forgive me, Your Honor, I appear to be experiencing temporary technical difficulties. If I could have 30 seconds of the court's time.
Sure.
Your Honor, in response to the court's inquiry, the state's understanding is that previously a request for revocation had been filed with the court in November of 2022, subsequent to a hearing on November 9th of 2022, at which time the defendant appeared before Chief Judge Rickey with court-appointed counsel Watts. It would appear that the request for revocation in response to the court's inquiry alleges multiple allegations, including failure to pay court costs, fines, and restitution as directed, as well as failure to report to the assigned probation officer as required.
Okay. So the state, Mr. Corson is alleging that you failed to pay fines and costs that were assessed by the judge, and that you failed to report to your probation officer. So
Okay.
that's the basis for the warrant to show cause.
Okay.
Bond is set at $2,500. So are you going to hire an attorney?
I'm not, I'd take a court-appointed attorney. I can't really afford to hire one.
Were you working?
No, as soon as I got released from jail, my mom and her husband came and got me. And then they immediately kicked me out on the streets for no reason. And I've been homeless ever since. And, I haven't been able to, I was in the state of Missouri. So I haven't been able to, keep my cell phone, and I was just supposed to call and check in and pay my fines through the mail. But I just wasn't able to do any of that, and then just getting by, surviving took place over that. I haven't been able to. Yeah, I haven't been back in Kansas since until a few days ago.
Okay. How'd you get to Kansas?
I hitchhiked.
Where'd you go in Kansas?
I started out in Gardner or Olathe, and then I ended up here in. I went through that area, and then Kansas City, Kansas. Then I ended up getting arrested in Lawrence and transported here
Okay. What were you arrested for in Lawrence?
for this warrant.
Okay. No new charges there?
No new charges, ma'am, Your Honor.
Okay. Well, I will reappoint Mr. Watts to represent you.
Okay.
And now you may be required to repay some of those costs. But that's something that will be determined at a hearing at a later date.
Okay.
And on this warrant to show cause, it looks like your judge is Judge Ricky. And so his warrant to show cause docket is July 11th
Okay.
of this year at 2:30. Mr. Watts will be informed of that court date. Your bond is set at 2,500 cash or surety.
Will do.
Okay, anything, Mr. Regier, on this case?
No, from the state, Your Honor.
Okay,
Thank you. You go. You good to go? All right. Put on back. Yep. All right. Benjamin.
Judge, did you say that date was July 11th?
yes, July 11th.
Okay, you must have got a more updated sheet than I did. Thank you.
I think that's right.
It'll be okay.
Okay. All right, and so, sir, you just came in and sat down. What's your name?
Benjamin Parmenter.
Okay. Mr. Parmenter, this case number, I just had it. It's 2025 CR 281. First, I want to read the complaint to you, make sure you understand what you are charged with, and then we'll talk about bond and attorneys and a court date.
Yes, yes,
There's
ma'am.
only one count on this complaint alleged to have occurred on June 19th of this year. The allegation is that you did unlawfully and knowingly violate an order issued in this or any other state as a condition of pretrial release, diversion, probation, suspended sentence, post-release supervision, or at any other time during the criminal case that ordered you to refrain from having any direct or indirect contact with Patricia Lentz, issued as a condition of probation, in this case, Butler County 24 CR 356. This is a violation of KSA 21-5924A4B1. It's called violation of a protective order. It's a Class A misdemeanor. Do you understand what you are charged with?
Yes, ma'am.
Okay. If you were convicted of this on a Class A misdemeanor, the maximum penalty is 1 year in the county jail, $2,500 fine. Are you going to hire an attorney?
I was going to try to get a court-appointed attorney.
Okay. Well, why do you think you need one? Court appointed.
I
You
can't I can't afford one right this minute because I'm taking care of 2 households and I got 7 kids out there.
Okay, no, do you have a job?
I work for a village decorative. I work like 1 week and then the next week I'm off. It's on and off weeks, so I'm looking for a new job at this time.
Yeah.
I got a couple applications in at this time. I'm just waiting on a call back.
How long have you worked at Village?
How long have I been gone away from home? About 1.5 years, 2 years.
Okay, and what is your salary?
I bring home $600 a week and that's it.
Okay. And you
If that, if even if I bring that home.
okay, and you say you have 7 children that you're supporting?
Yes, ma'am.
Are you supporting them under a court order?
No, I send my mom money and she sends it to Patricia. We all have Cash App, so we just send it back and forth.
Okay. So she's the mother of all the children,
Yes, ma'am.
and you're the father of all the children?
Yes, ma'am.
How much do you send?
I send half my check, so
Okay, you said you're supporting 2 households. You mean yours and hers?
yes. That's where it's getting hard on me at this time because I'm drowning in debt right now. Because
Do you have any other sources of income?
no, ma'am, that's it.
Well, I think with supporting 7 children on that salary comes close as to whether or not you qualify for court-appointed counsel, but I will go ahead and appoint counsel to represent you. I want you to know that you are most likely going to be required to repay the costs of that representation with
That's
your
fine.
salary that you
That's-
have.
That's fine.
And so on a misdemeanor,
We appoint Darren Patterson for the misdemeanors.
that's right. Okay. So your attorney will be Darren Patterson.
Okay.
Okay. He'll be notified that he's been appointed to represent you,
Okay.
but it is your responsibility to contact your attorney.
Yes, ma'am.
And then the next court date for you, well, let's talk about bond first. What's the state requesting on bond?
Your Honor, the state does acknowledge that the only count before the court is a Class A misdemeanor. However, the state does consider the specific charge before the court a very important crime. Additionally, this is the defendant of the state, our sense, has had 4 separate cases proceed to disposition before Butler County courts within the last 5 months, as well as at least 11 prior failures to appear, at least 4 felony person and non-person adjudications, at least 1 misdemeanor violation of protective order conviction, 12 non-person misdemeanors, and 5 other non-person felony convictions. Additionally, it is the state's understanding that the 4 Butler County cases that proceeded to disposition within the last 5 months all involve the same victim. So for those reasons, the state is recommending, besides a very strict no contact order, as well as GPS monitoring and cash or surety bond in the amount of $5,000.
Okay. So the state's requesting a $5,000 surety bond, no contact, of course, with the alleged victim in this case.
Yes, ma'am.
Anything you want to say about the bond?
No, ma'am. I was just wondering, is that 10% of the is that 500 of 5,000?
It depends on what bondsman you contact, but you will be allowed to contact a bondsman and set that up with a bondsman, okay?
Okay.
Okay, so $5,000 cash or surety bond,
Okay.
absolutely no contact. And by no contact, that means you can't call on the phone, you can't send messages through someone else, you can't go to the residence or where this individual works. If you go somewhere and she's there, you're the one that has to leave.
Okay, that's what I was getting ready to ask.
Yeah, it's your responsibility.
Okay,
Okay.
all right, thank you.
So your new court date then, since Mr. Patterson's been appointed to represent you, will be on September the 8th at 8 o'clock.
Okay,
So if you make bond, make sure you contact Mr. Patterson and stay in contact with Mr. Patterson.
how long does it take for booking to get to bond paperwork?
Oh, it depends on what they've got going on for the day, I'm sure.
Okay,
Okay. Any questions?
no ma'am,
Okay. you're free to
thank
go.
you.
Your Honor, next we have Justin Thorburn.
Okay. Okay, Mr. Thornburn, can you hear me okay?
Yes, ma'am.
Okay, case number 25 CR 159. Mr. Regier is here for the state. And this is your first appearance, is that correct on this case?
Yes, ma'am.
Okay, I'm going to go through the complaint with you, make sure you understand what you're charged with, and we'll talk about bond and an attorney and a new court date. There are 3 counts on this complaint, all alleged to have occurred on January 22nd of this year. Count 1, that you did unlawfully possess an opiate, opium, or narcotic drug or stimulant designated in subsection D1, D3, or F1 of KSA 654107 and amendments. In this case, it was methamphetamine. That's a violation of KSA 215706 AC1. It is considered a level 5 drug felony. Count 2, on the same date that you did possess with the intent to use drug paraphernalia, that being a syringe and a pipe. Possession of paraphernalia for use is considered a Class B non-person misdemeanor. It's a violation of 215709 B2 E3. And count 3, that you did unlawfully and knowingly carry a bludgeon, sand club, metal knuckles, or throwing star. In this case, it was metal knuckles. That's a violation of 216302A1. Criminal carrying of a weapon. That's a Class A non-person misdemeanor crime. Do you understand what you're charged with in all 3?
Yes, ma'am.
Okay. The most serious one is count 1, which is the level 5 drug felony. If you were convicted on that, 5, the maximum penalty, and this all depends on where you fall in the categories, would be 42 months in prison and the minimum 10. So, Mr. Thornburg, are you going to hire an attorney to represent you?
I don't have the money to hire one, but I'd like court-appointed one if possible.
Okay, how come you don't have the money? What are you doing with your time?
Right now, I'm currently not working.
How old are you?
I'm 26.
26 and not working?
I just got out of inpatient not that long ago, and I've been trying to get a job, and with everything going on,
When did you get out of inpatient treatment?
About 2 months back, maybe.
2 months?
3 months. I don't know. My dates are off so much, and I was working with my corrections officer about trying to get back into an inpatient when they picked me up. So.
Okay, where are you out on probation out of?
Butler County. I'm on corrections.
Okay. Okay. Who was your attorney in the other case?
I cannot remember his name.
Was it Mr. Watts?
Yeah, it might have been.
Okay, I will go ahead and appoint Mr. Watts to represent you in this case. You may be required to repay those costs, and there would be also a bids application fee. that I will assess. That's $100. And this will be assigned to Judge Satterfield. And her next felony preliminary control hearing date is July 14th at 2:30. So that's when your hearing will be. Mr. Watts will be informed that he's been appointed to represent you. He'll know about the court date for you as well. And now we can talk about bond. Mr. Regier, what's on the bond?
Your Honor, the state's information would appear to suggest that bond has already been set in this case.
Okay.
And the state is not making any recommendations that the prior orders of the court be modified. Besides the fact that those orders have already been made by a sitting judge in this matter. This is defendant who, within the last 15 months, the state understands has had 4 Butler County cases in one fashion or another. It would appear that 2 misdemeanor cases, 21 CR 485 and 23 CR 250, 2566 proceeded to either sentencing or disposition concerning a request for revocation in March of 2024. There would appear that recently a case did come before the court, Judge Webster last month on May 19th, and it would appear that there is a 4th case, 23 CR 448. The state's information appears to suggest that there has been at least 1 recent failure to appear in that case as recently as April of 2025. And the state's understanding is that matter is currently set before Judge Crum later this afternoon on a request for revocation.
Okay. Well, your bond is set at 20,000 cash or surety. And Mr. Thorburn, it sounds like you've got so many problems. I guess I'm not too surprised you didn't know who your attorney was in the other case. Maybe you've gotten it all confused with so many cases pending. So I'm going to leave your bond at 20,000 cash or surety. You've got your new court date, you've got an attorney, and you know which judge you're going to be seeing. Okay?
All right.
Okay, we'll be in recess.
Morning.
Good. Well, it's afternoon.
Well, I guess it is after.
That's okay. What's your name, sir?
My name is Les Coker.
Okay. I'm showing this as case number 2025 TR 1445. Mr. Regier is here for the state. Mr. Coker, first I'm going to go through the complaint, make sure you understand what you're charged with, and then we'll proceed from there. There are 3 counts on this complaint, all alleged to have occurred on June 19th of this year. Count 1, that you did operate or attempt to operate a motor vehicle while under the influence of alcohol. Having been convicted of DUI on June 20th, 2012 in Marion County, July 22nd, 2013 in Marion County, October 9th, 2019 in Sedgwick County, and also December 4th, 2020 in Sedgwick County. There's an alternative count on this, which says that you were operating or attempting to operate a motor vehicle under the influence of drugs or combination of drugs that to such a degree that render you incapable of safely driving with the same priors. And then a second alternative, operating or attempting to operate under the influence of a combination of alcohol and drugs with the same priors. So they're charging this as a level 6 non-person felony violation of 8-1567A B1E. Count 2, that you were operating that vehicle while not equipped with an ignition interlock device as required. This is a violation of 8-1017A4. Count 3, on the same date that you were driving a 2006 Gold Jeep at 205 West 7th Avenue in Augusta, Butler County, Kansas, which was involved in an accident resulting in damage to an unattended vehicle or property. In this case, it was a car owned or a vehicle owned by Brian Bonham, and that you failed to stop and locate the owner of that vehicle or property and notify them of your name, address, and the vehicle registration number, or also that you failed to attach a note to the vehicle letting people know who you were and your vehicle registration number, and also that you failed to notify the police about this. This is a violation of 8-1605. It's a first offense of that crime, leaving the scene of an accident, a Class C non-person misdemeanor. You understand what you're charged with?
Yes, yes, I do.
Okay. Are you going to hire an attorney?
I guess I will.
Well, it sounds like you probably should, honestly. Because with a felony, that's pretty serious, and I would advise you, I guess, to hire an attorney. Do you know who you're going to contact?
Probably lost of West Holiday.
Okay. Okay. Then I will allow you some time to do that. What's bond on this? I don't think there's been one set on this. Mr. Regier, recommendations?
Your Honor, in this matter, the state is seeking a cash or surety bond in the amount of $6,000. I believe the court has already addressed the level of count one as well as the 4 prior convictions in this case. So the state does consider that a very serious offense, not to discount the other 2 remaining counts in this matter. Additionally, pursuant to page 3 of the affidavit, it would appear that at the time of the incident, the defendant admitted to law enforcement consuming multiple alcoholic beverages, as well as law enforcement, upon conducting a lawful search of the vehicle, located 25 cans of alcohol on the driver's side floorboard of the vehicle. Therefore, the state is also recommending a strict no consumption of alcohol order, as well as scram monitoring.
At the scram, you say?
That is the state's recommendation, Your Honor.
Okay. Okay, state's recommending I require a bond of 6,000 cash or surety. Do you think you can make that bond?
I don't think so. Is there any way I can OR?
Oh, I'm not going to let you OR on this. This is pretty serious. Are you employed?
No, I'm retired.
So.
And Your Honor, one
Yes.
other thing I would add, upon further review of the affidavit, this would also appear to be a case where the defendant attempted to flee before being apprehended by nearby civilians, and therefore the state does reassert its recommendation that 6,000 cash or surety subject to scram monitoring is appropriate.
Yeah, well, Mr. Coker, I'm debating on the amount. I'm definitely going to require absolutely no alcohol or illegal substances while you're out on bond. I'm going to require the scram monitoring. I'm going to set the bond at 4,000 cash or surety. So if you make bond, you make sure that you absolutely consume no alcohol. You also have to get fixed with that scram monitoring device. Your new court date, it's like this will be with Judge Ricky, will be on August the 4th at 2:30. Any questions?
No. No, Your Honor.
Okay. Okay. We'll be in recess on your case.
Thank you.
Mhm.
That's all for the jail, Your Honor.
Okay, thank you.
Have a good day.
You too. So Mr. Regier, it looks like we have some others that were on here, but I don't know, maybe they didn't get served. What do you think?
Your Honor, I believe I am in a position to take up the other matters in whatever order the court may deem appropriate.
Okay, we'll start then with Tanya Henry, 25 CR 121, and she's not appearing. Mandy, have you heard from anyone else?
I have not, and her summons was not served. The
Okay,
alias summons was not served.
okay. What do you want to do on that case, Mr. Regier?
Your Honor, the state's information is that summons and alias summons were filed with the court, and service was attempted at 2 different addresses. The state's information is that with respect to the summons, that came back unable to serve, with an indication that would appear to suggest the defendant did not reside at that address. Insofar as the alias summons is concerned, the state's information is that the return of that came back to suggest that the address was a vacant house. In light of the 2 prior attempts at service, both by summons and alias summons, the state is requesting a bench warrant or an arrest warrant, whichever the court may deem appropriate, and I can make appropriate recommendations to amount if the court is prepared to proceed in that fashion.
Yeah, I would, and this is from July of last year, so I would say it's time to get this individual served and found. So I'm going to issue an arrest warrant. How much do you want on the bond? It's a felony.
Your Honor, the state is requesting an amount of at least 5,000 cash or surety, subject to all standard conditions, including no contact with illegal drugs, given the nature of the charges before the case. Additionally, it is the state's understanding that pursuant to paragraph 10 of the affidavit, law enforcement retrieved a backpack from the vehicle containing prescription bottles labeled with the defendant's name, as well as a small glass vial containing a white crystalline substance and fentanyl test strips. And it is the state's understanding that this is a defendant with a prior history of drug-related convictions, at least 1 misdemeanor possession of marijuana and 1 felony possession of opiates.
Okay. I'll grant the state's request for 5,000 cash or surety with standard conditions.
Thank you, Your Honor.
And see if we can find her that way. I then have Marshall Wilkins, 25 CR 231. Let's see what we have on Wilkins. That's a level 9 felony. What's the state's request on this?
1 moment, Your Honor. Yes, Your Honor. This is another case where both a summons and an alias summons have been filed with the court. The return on the summons would appear to suggest residential tack down, albeit on a line somewhat uncustomary insofar as the return is concerned. With respect to the alias summons, it would appear that it was sent to a specific location in Wichita, and it would appear that that attempt at service was unsuccessful as recently as June 5th of this year. So at this time, the state is requesting a bench warrant or an arrest warrant, whichever the court deems appropriate.
Okay. I will grant the state's request for an arrest warrant, and I don't know, I guess I'll make it 2,500 cash or surety on the bond. What kind of a business is Bestmark? I've never heard of them.
I cannot advise the court as to that, Your Honor, although the state would request a brief opportunity to be heard on the issue of bond amount at this time.
Yes, go ahead.
Your Honor, while the state does understand the court's prior indications on the record, in light of the level of the charge, the state is recommending a higher bond of at least 4,000 cash or surety. Pursuant to the affidavit, pages 1 through 2, this would appear to be a case involving an amount of issue in excess of $3,700, as well as the defendant being identified by photographic evidence. Additionally, this is a defendant with a history of convictions that the court may consider relevant. Besides 2 felony burglary adjudications, as well as adjudications for misdemeanor theft and criminal use of weapons. This is a defendant with a number of felony convictions the state does consider relevant. Felony burglary, felony obstructive legal process, as well as felony attempted voluntary manslaughter. So for those reasons, the state is recommending a higher amount.
Yeah. Well, with his history, I think that's appropriate. So I'll grant your request, 4,000.
Thank you, Your Honor.
Cash or surety. Okay. And then the last one is Cody Showalter, 25 CR 268. And did he post a bond and then not appear?
One moment, Your Honor. Your Honor, this is a case where it would appear that a motion to continue was filed with the court on June 13th, approximately 1 week ago. I, of course, cannot speak to the substance of the motion, but I do have a note in my file to suggest that continuance has been agreed to the date of July 2nd, 2025 by my colleague, Ms. Norris.
Okay. Well, let's move it to that date then. So he must have an attorney.
Yes, what was the date again?
July 2nd.
Okay.
And that's with Judge Webster.
What time would that be, Jared?
Your Honor, it is the state's understanding that Judge Webster traditionally holds court at 9 o'clock in the morning.
Okay.
Okay. All right. Well, that takes care of that docket, I think. Did you have anything else, Jared?
Not from the state, Your Honor.
Okay. Al, anything else in court security?
Nothing, just good seeing you, Judge.
Yeah, you too. Thank you, Mandy.
Thank you, Judge.
Okay, we'll be in recess.